Mr. Shaw.
Case first, which is SJC-11342, Commonwealth.
All right, good morning, Mr. Shaw. As the Bible says, the second shall be first. So, but why don't you wait until...
1 second. I don't know what's wrong with this. It doesn't. And it's lit. I don't know what that means. Sort of permanent.
Oh, that happens with Justice Courtees. I think it doesn't mean that much.
It doesn't.
Yeah, I'm not sure that that works, because I remember that that was an issue with Justice Courtee. But I forget what exactly. All right, you may begin now. Thank you.
Good morning, Chief Justice Gantz, and may it please the Court, my name is Robert Shaw. I'm privileged to appear today on behalf of Timothy Cassidy. Two issues will likely consume my time this morning. The first concerns what we assert were unwarranted judicial limitations on defense evidence, and the second concerns a supplemental jury instruction in response to a jury question. Now, in addressing the judicial limitations, for obvious reasons, I'll be addressing representative examples this morning. But before getting to the specifics, I want to address more generally the core problem that I assert we present to the court and that I think coursed throughout this trial, and that is that this murder occurred in an isolated parking lot without witnesses. And so the government's case was not primarily centered on demonstrating what's happened specifically in that parking lot, but rather it was focused on surrounding circumstances. And the government focused on surrounding circumstances to try to demonstrate that Mr. Cassidy was conscious of his guilt and that those surrounding circumstances did not corroborate and were not consistent with his version of events. Mr. Cassidy, on the other hand, really did only what a defendant could do. He told the jury what he saw in that isolated parking lot, and then he focused on surrounding circumstances in order to demonstrate that those were consistent with and explanatory of what happened in the parking lot and what led to it. And the problem we have in this case is that when defense counsel sought to build that complete picture for the jury, piece by piece, brick by brick, he was obstructed in having done so. Now, beginning with the consciousness of guilt evidence, which was really the primary component of the government's case, the prosecution focused on various actions.
Excuse me, wasn't there also evidence as to the motive that the defendant had to murder his friend, including financial hardships and loans and so forth? So it wasn't purely based on consciousness of guilt.
Oh, certainly not. There was consciousness of guilt. There was motive. I'm just addressing the first issue as consciousness of guilt. There was certainly a lot of evidence surrounding the murder that the prosecution focused on. With respect to consciousness of guilt, the prosecution focused on various actions of Mr. Cassidy in order to assert that he was conscious of his guilt. Mr. Cassidy, on the other hand, wanted to focus on those same actions in order to demonstrate why it was he was engaging in them. In other words, to rebut the notion that he was conscious of his guilt. Now, the most significant evidence in that regard concerns schemes that he engaged in to plant a firearm on Kevin Hayes and to implicate Kevin Hayes. The judge allowed the prosecution to focus on a number of letters that Mr. Cassidy had written from jail in order to demonstrate the schemes that he was engaged in. But the judge would not allow defense counsel to question, based upon earlier letters that Mr. Cassidy wrote, which demonstrated the fact that how he had been tipped off that a gun had been put in his garage and his effort to plant it.
Those earlier letters?
Well, there was an Exhibit B that defense counsel repeatedly tried to get into evidence and repeatedly tried to at least question concerning, which involved how Mr. Cassidy, when he was in jail, had actually been attacked by somebody, and this turned into this person actually sort of tipping him off about what happened, and that attack apparently, according to Mr. Cassidy, was related to Kevin Hayes. But the important point is that this was explanatory of how Mr. Cassidy became aware that a gun was in his garage and what led to him trying to plant the gun back on Kevin Hayes, but the judge wouldn't allow it. Now, even if the court were to overlook that aspect of the case, the fact is that Mr. Cassidy took the stand once the judge limited the defense, specifically because the judge had limited defense. And he took the stand to try to explain how it was he became aware of the gun, what he was doing, and again, the judge would not allow it. The judge would not even allow him to testify as to his personal belief about how the gun got there. So what we assert is that these are really extraordinary limitations. I mean, the government is saying to the...
Stop there. I mean, what would be the basis on which to testify to his personal belief as to how the gun got there? I take it it's coming in for the truth of the matter, yes?
Well, not necessarily. I think there's several bases, but first and foremost, this is rebuttal to consciousness of guilt evidence. The government is saying that he knew where that gun was, he was aware of it, and he tried to plant it on somebody else. You're conscious of your guilt. You're trying to implicate somebody else in the crime. He's saying, no, I need to explain why it is I knew that gun was in my garage and why it was I was trying to plant it back on Kevin Hayes. His understanding is essential to complete that picture. So that's first and
Well,
foremost.
is it your view that if he had not testified, it would be admissible?
Well, I think that's a separate issue. I mean, I think that
Well,
first you can...
let's assume that you sought to offer it before he went on the stand. A letter written by your client explaining something, how would that come in?
Well, I mean, it's rebuttal to consciousness of guilt evidence. It concerns his state of mind. And it could have been limited.
Okay,
And,
I grant you perhaps the relevance, but how would it come in as it's on? I mean, it's a statement of the defendant, but of course it's being a statement offered by him.
right, and it's also it's also rebuttal evidence concerning his state of mind.
So why does a different rule apply just because it's rebuttal evidence?
Because it's going to his state of mind. It's rebutting the notion that he's conscious of his guilt.
The guilt evidence on this point was the letters to, I'm forgetting to whom, but saying you're going to get a package, do all these things with the package, and if you can put it under this Crown Victoria car.
Well, the letters that were at issue actually were earlier letters where he was trying to determine, you know,
That's the letter the Commonwealth was using.
Right, the Commonwealth was using letters that show that he was engaging in a scheme to plant a firearm. And the judge is allowing in just that portion which shows the schemes that he's engaging in, but is not allowing in earlier portions or evidence which concern the fact that he was tipped off, how he learned that a gun was in his garage. And by the way,
That's offered for the truth of the matter asserted, that he was indeed, I mean, isn't that offered for the truth of the matter asserted, that he was tipped off, that in fact
well, Your Honor, I think there are
Hayes
three...
had placed the gun there?
There are three different grounds. Certainly, it is rebuttal consciousness of guilt. That can come in, not for the truth of the matter asserted. I think it involves Bowden evidence because we have a firearm that's in a paint can that was manufactured 18 months after Mr. Cassidy was arrested and placed in jail. So he couldn't have put it there, okay? And the defense counsel wanted to...
Commonwealth's, I don't know this, but its theory doesn't depend on whether he actually put it there, does it?
Well,
It depends on the fact of, it doesn't work. Doesn't it depend on the fact that he's writing, he now knows where it is, he's got it wrapped in I forget what the kind of bag it was, and he's telling somebody, get it and do this with it.
put it back on Hayes, right. There's no doubt that his actions were wrongful in the sense that he was trying to plant the gun back on Hayes, but the government is presenting a partial picture which makes it look like, look, you knew where the murder weapon was in your garage, and now you're trying to plant it on somebody else to implicate them. Whereas what he is saying, which is an important aspect of his state of mind, is that no, that gun was placed in my garage by someone who had access to the house 18 months after I was arrested and imprisoned, and I couldn't have put it there. And I did the stupid thing of trying to put the gun back on him because he's the person who actually killed James Madonna, and he put the gun there with the idea that he's going to then tip off the police when my trial begins, and I'm going to get convicted, and it's going to be a done deal, and there's no way that I'll ever overcome this. So I think it's consciousness of guilt rebuttal. It's Bowden in the sense that
When he testified, was he allowed to testify to that?
he was limited in his testimony, as defense
Limited,
counsel
what,
said.
What was he allowed to do and what was he not allowed
He
to
was
do?
allowed to say he found out about the gun, and he was allowed to say essentially that, that he saw James Madonna, he saw Kevin Hayes kill James Madonna. And as the Commonwealth says in their brief, they say, well, that's sufficient. And our
Allowed to say that the reason that I did this stuff with the letter about getting it to Kevin Hayes was that I wanted to put it back on the person that I thought did it?
he was not allowed to say, as I recall the record, that his understanding was that Kevin Hayes had planted the gun in his garage. What he was allowed to say is that he wanted to put it back where it belonged. It was very limited, and you know that's the problem, is that there were these persistent limitations taking place. So, in summary, I think it goes to his state of mind. It's consciousness of guilt rebuttal. It's Bowden evidence. It's connected to this scenario where defense counsel was actually asking during the trial a detective, what did you do with this stubborn fact that you have the murder weapon that was actually placed in a paint can that was manufactured 18 months after Mr. Cassidy was imprisoned and put in jail and arrested? And the judge would not even allow defense counsel to pursue that inquiry. And then,
No, there was a search of his home. There was a search of the home.
that's
correct?
right, and the garage.
And I don't know how the testimony played out as to whether or not there was a paint can there, or whether or not during the search of the garage they simply didn't think to look into a paint can, or whether or not there was any indication as to whether or not that paint can or something was there at the time of the search.
Well, Your Honor, the paint can couldn't have been
Couldn't
there.
have been there, okay.
Because it was manufactured 18 months after Mr. Cassidy was arrested, and he was arrested, a month or so after this murder occurred.
And how did it play out at trial with regard to the failure to find the gun at the time of the search and the
I think-
gun's reemergence in the garage?
I think the gist of the record is that the police essentially concede that they did a thorough search of the house and the garage, and the gun wasn't there.
And what was the, I apologize, I probably should know this, but what was the evidence that it was there 18 months later? I mean, I know it ended up in this package, but
Well, Mr. Cassidy sought to have his father go in and try to find a generally described can that he had been informed was a paint can, and no, in the garage. And his father did that and retrieved it, and then began these events unfolded where he sought to,
testify, I found it in the garage?
yes. And then these events unfolded where he was trying to then do something that was inexcusable to.
So how did the Commonwealth explain, or did the prosecutor explain how the gun got there, how the police missed it, or
Well, the police didn't
it's
miss it,
very
Your Honor,
confusing.
because it-
I mean, the Commonwealth conceded that it wasn't there at the time they did the search.
Commonwealth concedes that the paint can was manufactured
Okay,
18
so
months
so,
afterwards.
so it's obvious then, isn't it, that to anybody that this paint can or that this gun was put in the garage while the defendant was in jail?
Right, but there could have been different explanations for that,
Well,
not
except that the
necessarily.
defendant couldn't have done it.
Well, I mean, I suppose one could speculate or wonder whether somehow, it got put there afterward by someone working with Mr. Cassidy, but that's the reason, to have that huge gap in the evidence. And defense counsel should have been able to inquire and cross-examine and ask the police, what did you do with this fact? What did you conclude in your investigation concerning how this gun got into that paint can, if you concluded anything? And again, the judge cut him off. And so there were these repeated attempts to elicit evidence, and the judge repeatedly cut him off. Now, I would also say that I think that this evidence is relevant to third-party culprit as well, because it's very intertwined and connected with Kevin Hayes as the third-party culprit. It completes a picture of a picture with a lot of other details.
Help me with that. I mean, the fact that he thought that he thought that Hayes had put it there is not evidence. I mean, that's pure
Well, certainly it's evidence of
conjecture.
his state of mind.
Right, but it's not evidence that in fact Hayes did put it there.
No, I don't think it is necessarily, though I think that there's other evidence concerning Hayes, and it fit into a larger picture. But again, there are multiple grounds in which this evidence should have come in.
Well, what is the third-party evidence that didn't come, the third-party evidence that really is, that not just what he thought, but that would suggest Hayes did do it?
Well, see, and this is the difficulty, and this is why we have this core problem, is that you have a drug deal, you have allegedly a drug deal in a parking lot that's isolated and there are no witnesses. You have allegedly events which were meant to create the circumstances for this drug deal, which were meant to be secretive. So the only option Mr. Cassidy has is to look at surrounding circumstances concerning Kevin Hayes. And don't forget, we have his testimony. So Kevin Hayes is directly linked. There is a direct link between Kevin Hayes and this murder because we have it from Mr. Cassidy's testimony. And then we have a number of surrounding circumstances. The loan that he engaged in with Joe Angelo, the call from Cassidy to Hayes at 6:05 on the night of the murder, calls from Hayes to this drug supplier, Kelly Croce, the next day, things that Hayes did, acting surprised that Madonna was killed, with the victim's son when we know that he already knew that because he had called somebody about it, racking a shotgun and threatening Mr. Cassidy following the murder. But the defense has to be able to address these details. The defense has to be able to address these surrounding circumstances in order to tie it in. And the judge was sort of taking piece by piece and saying, oh, well, that's not relevant, or just sort of reflexively denying requests and attempts by Mr. Cassidy's counsel to get this evidence in the record and complete that very important picture.
Did Mr. Cassidy's counsel attempt to explain to the judge what the constellation of
Multiple
facts were before
Multiple times.
offering each piece
Multiple
of this
times, Your Honor, and
evidence?
you'll see in the record that very early on, he really explained the entire theory of the defense. And surprisingly, defense counsel was very open with the prosecution concerning what the theory of the defense was, I think well over a year before this trial began. I mean, he was very disclosed a lot. I just want to be sure I can address the jury instruction issue before my time runs out. We assert that when the judge's instruction is evaluated with reference to the question the jury asked, that it was improper. And that is the proper context, looking at the question that was asked. And I think there are three basic points that will help the court resolve this issue. The first is, as the court knows, it's fundamental that a defendant has no burden of proof. And when a defendant presents a defense, the jury has to evaluate that defense with reference to whether, in light of that evidence, the government has satisfied their burden of proof. That's a very important principle, that the defendant can present a defense, but that the jury understands that that evidence must be evaluated relative to the government's burden. If a prosecutor wants to argue against defense evidence, sure, they can do that and attack the credibility of the defense, but they have to do it very carefully, they have to do it very consciously, and they have to do it in terms of arguing that we have satisfied our burden of proof, not as occurred here, that the defendant failed to prove his defense.
Well, I mean, again, this is personal for me because at the end of every criminal case I did, I would turn to the jury and I would say, the defendant has no obligation to offer any evidence. The burden rests entirely with the Commonwealth, but of course the defendant has the opportunity to call witnesses, and Mr. Defense Counsel or Ms. Defense Counsel, do you wish to call any witnesses? And they either would or they would say, no, I rest. Was that error? Is that error to?
Well, that's a more full explanation than we have here. And again, you have to realize that you can't just rely on the general instructions because we have this question from the jury where the jury is signaling that they want to penalize, or they're considering penalizing Mr. Cassidy for failing to produce a very hostile witness. Now, when the judge says to the jury in response, well, Mr. Cassidy could have called a witness, he had the option to, but he's not required to. You can't equate not requiring a defendant to call a witness with not drawing an adverse inference against a defendant or penalizing a defendant. And that's the critical error that occurred in this case. It's not enough to say he's not required to. Could you imagine if we instructed juries relative to a defendant testifying, and we told them, well, the defendant has the option to testify, but he's not required to? Clearly, that would fall short. Why would it fall short? Because we're very clear to tell the jury, you cannot hold this against a defendant, okay? And the final point here is that it doesn't really matter what we call it. The government focuses a lot on appeal in terms of the words burden of proof. Here, what happened is that the jury was considering penalizing Mr. Cassidy for not producing evidence. And if they're going to take the step and actually penalize, they are shifting the burden to him.
Did they ask specifically why they didn't call, could the defendant call Hayes?
Yes, that was their question. Could the defense have called Kevin Hayes as a witness?
Thank you.
Thank you.
May it please the court. Good morning, Chief Justice Gant, Justices. My name is Attorney Thomas M. Quinn III, First Assistant.
You may want to lift your voice a little bit louder.
I
or
will,
move the
fighting a
microphone
little
bit
cold.
closer. Great, thank you.
My name is Attorney Thomas M. Quinn III. I'm the First Assistant District Attorney in Bristol County. With me is Yomi Cho, Appellate Counsel. I was one of the trial prosecutors in this case against the defendant, Mr. Cassidy. The defendant received a fair trial from a very experienced trial judge who gave the defendant wide latitude in pursuing his defense or defenses. There were, counsel has referenced times when evidence was excluded, and I would argue to you that the evidence was appropriately excluded in the exercise of discretion because the evidence was hearsay evidence, it was cumulative, not reliable evidence, among other things, and simply not admissible.
Why isn't it admissible, though, you know, if the, on the Bowden defense, and you're looking at what did the police know and investigate? And so, at least as I took it from the Commonwealth's brief, the judge allowed questions to the state police officer about, did you hear? But she would not allow questions to witnesses who are the actual ones who spoke to the police officer, like the wife of the victim.
With respect to the third-party culprit, I think that...
That she thought it involved drugs, or, I mean, there was a variety.
Well, there were a variety of things, there's a number of examples, but I think the judge initially, when there was an attempt to, I think, justify admission of evidence with third-party culprit through defense's questioning, the judge indicated, is there a substantial link here? He said, no, there isn't. The defendant was called. She indicated that I will allow you to pursue further inquiry if later in the case, through the testimony, something will come to light. But I think it depends on the specific example. I would suggest that the defendant opposing counsel in this case is basically saying, I'm allowed to put forth my defense in the way that I want to put forth it. There was significant, even if it's inadmissible evidence. The paint can, for example, that was a major issue. The defendant was incarcerated after his arrest for 18 months. There were a variety of letters. There's a long volume of evidence of what he was doing. And he attempted, in his attempt, it was referred to as like his scheme or his first initiative to try to plant evidence with respect to Mr. Hayes, who he personally identified as the shooter. So this is a different, he said, I was there, he was the shooter, not trying to implicate him through just cross-examination of another person. I don't see how that would be admissible, that, how did he come to learn that the paint can was in his garage when, in fact, he's in jail? It's clearly hearsay. It's, even if you say it has some relevance to the case, I would question that, but even for the sake of argument, what does he really get out of that? Arguably to further implicate Kevin Hayes, or hypothetically to say, well, Kevin Hayes put it there?
Well, I think the defendant says that he was entitled to it because you were using the paint can as consciousness of guilt evidence, so it's kind of a response to that.
Well, I wouldn't, certainly there was significant conscious guilt of evidence. The primary argument would be that the defendant, in this case, from jail, had someone put that paint can in there with the murder weapon. That was the murder weapon.
What's the evidence that the defendant had somebody put that paint can?
Well, I think it's a reasonable inference. He's not in jail. He's in jail. The paint can didn't exist at the time of the murder. I think that's a reasonable argument.
And this is his own garage?
Yes.
Why would a defendant put the murder weapon in his own garage? I mean,
Why would he?
if the police don't have it, let them continue to not have it. I mean, why would he give it to him?
Well, if you read this, he engaged in a number of, I will call it, instances or schemes to attempt to plant evidence. I can't speak to what was in his mind. Our position at the case was this was a desperate person. Arguably, there was a strong case against him. Now, he's sitting in jail for 18 months, writing numerous letters and concocting a variety of schemes that included attempting to get someone to make up a false test evidence about what happened in the parking lot, to sending a videotape to someone else of Kevin Hayes' interview to get them to try to plant the gun. So why would he do it? I would say he is attempting to, excuse me.
Why is it a reasonable inference? That's the question. Why is it a reasonable inference that he would put the gun back in his own garage?
On the surface, it may not be reasonable, but I think
Is that the only basis that it came in? I mean, you said it. Was that part of the evidence, that he put it there?
well, his father testified eventually that he put it there.
I'm sorry, that the father put it there, or
Well,
that he?
eventually,
he,
the
defendant,
father
put
went,
it there?
excuse me, strike that. He went to pick it up at the behest of his stepson. But I would say, if you're saying it seems implausible that he would put the murder weapon, which was his own gun, in that paint can, that furthers his attempt to implicate Hayes as the killer, which he testified to.
Oh, so the Commonwealth's theory was that he was trying to create a third-party culprit.
Yes. This was just one aspect of it. He testified significantly to Hayes, what he did at the scene. So that was one aspect of it. But I don't see how that would be admissible, that his state of mind, his knowledge of how he would say that paint can got there, which we all agree was not in existence when they searched the home. They searched the home 2.5 days, almost 3 days after the murder. It was a thorough search. They found shell casings, a box of ammunition that had 5 missing that were associated later with that gun. Isn't it fair to conclude that he didn't put the gun in his own house? That would be more plausible at the time of the murder. And when he fled, or prior to him fleeing, he discarded the gun somewhere.
Well, I'm sorry, go ahead.
I was just going to ask, I thought that there was evidence that Hayes moved in with the victim's wife shortly after the murder, and that the victim had been a very close friend of the defendant and had a key to the house and access back and forth into the defendant's house, knew where the gun was kept, and often borrowed that gun.
Well, I think
And so it was conceivable that Hayes then could have also had access to the gun. Was this all in evidence?
yes, the victim, James Madonna, was a very close friend of the defendant. There's no question about that. He had access. The testimony was that they had access to each other's home. Hayes was the brother-in-law of James Madonna. His sister, Pam Madonna, was married to him. I don't believe they were very close friends. In fact, there was testimony that there was animosity from Hayes towards him.
Yeah,
So
but Hayes moved in with his sister.
there was testimony, I believe, briefly, that was the case.
It was after the murder, right?
I believe so.
And you don't dispute, there was evidence that Madonna had, while while he was alive, free access to the Cassidy house.
That was the testimony. They were very close friends. They were like brothers. So apparently, yes, apparently that was the testimony. You're saying victim had access to Cassidy's house?
Yes, meaning that, and I think there was evidence of a key, maybe?
I think someone said that he had a key. That's the victim. I don't recall Hayes had...
I'm just following up on
Yes.
this next question, that there's an argument that Hayes could have put it there, right?
Yes, that was the argument throughout the course, and he testified to this, the defendant. There was ample evidence of his point, the defendant testifying, and it wasn't counsel's decision whether he should testify. He could inform him. It was ultimately the defendant's testify, and it was like sort of a threat made at sidebar a couple of times. There were two things counsel said, I think, trial counsel. I don't want to try this again, and you're going to make me put him on the stand. That's the defendant's choice. But in any event, the defendant testified and gave ample evidence that he was afraid of Kevin Hayes, that he fled, and that Kevin Hayes was the third party, not the third party, the party culprit.
Yeah, but these other things would either back him up or not back him up.
Well-
I mean, the fact that he testified is nice, but it's standing alone. It's not as nice as if he could get details
I think that's
from other sources. And I guess I had understood this as, I thought the Commonwealth was suggesting that his attempts to take the gun away from the house was the scheme, not that he...
Initially,
So I guess I just don't really understand this business of how the defendant would have, from jail, put the gun in
not
his
him,
own house.
obviously not him.
What was the evidence, by the way, that was kept out about how it was he found out about the gun? What evidence was it that he wanted to put in that he found out that the gun was there? How?
I'm not sure if he made a specific offer of proof about that, but well, I don't want to assume, I think it was clearly that Kevin Hayes put it there. And again, that,
Some letters that had some information about that didn't come in?
yes,
From whom?
I believe, from the defendant, that was, I think, what counsel is referring to, that a letter didn't get in explaining the defendant's knowledge as to how the gun got there. But I still say respectfully, there's a standard of admissibility to all these things. There were many instances of what the Commonwealth would say of...
Did the defendant have claimed to have direct knowledge of Hayes, of putting the gun in the garage, or was this a theory?
Theory, I would say. That's my recollection of it. I mean, he again, was incarcerated when this was all going on. The paint can got manufactured, say, in 2009, and then ended up in the garage at some point, which led to...
But there was no evidence that John Jones or somebody told the defendant that Hayes had the gun and he was going to put it in the garage, or he was going to set him up?
Not that I recall.
Counsel, what was the judge's problem with this particular evidence? Was it that it was not true third-party culprit evidence, or was she concerned that the evidence was not admissible on some hearsay ground, or what was her problem with it?
Well, Justice Hines, I would just say, she, I think, in some cases would just say, sir, I will deny that. So I don't think there was an explanation for every ruling that she made excluding this evidence. I think her problem in this case is, if you're referencing the gun and the paint can, which
Yes.
she said he wasn't there. He's in jail. If he's in jail and he's not there, how should that come in? And again, I think it was
So
Chief Justice...
she wasn't excluding this on the usual grounds that this isn't real third-party culprit evidence. She had a problem with the way that the defendant was trying to prove this. Is that how you understand it?
I would, and I think that is a thread that goes throughout a lot of these questions that are far too numerous to touch upon. So I think just limiting that, I think that's an appropriate use of discretion. And with respect to the third-party culprit, Just as like I mentioned, isn't he entitled to maybe corroborate that? I think he is on the appropriate, if the evidence is admissible. And he made no argument about the specific elements of third-party culprit. This is the defense, other than saying there is no substantial link here. This is prior to the defendant testifying. Therefore, this evidence is not going to get in, again, the various attempts to do it.
So just so I'm clear
Yes.
on this rather bizarre set of events. In the opening statement of the defendant, did he say this murder was committed by Hayes, not my client? Or did that come out only at the end? I mean, was the third-party culprit there up front?
No, I don't specifically recall, because I don't know, obviously, if the decision was made for him to, when the decision was made to testify.
But going to Justice Hines' question, did the judge know that the theory of the defense was, at the beginning of the case, that Hayes did this, not Cassidy?
Well, there's some indication in the record, going back to the first time, the trial happened in January of 2011. The prior trial was on in June. The defendant indicated at that point the defendant would testify, and request for third-party culprit evidence was allowed. And then the trial got continued because of the last, I don't know if you remember, he presented evidence on the eve of the trial that trying to plant the gun. Again, case got continued for the Commonwealth to investigate, and then 7 months later went forward. So I think she had a view of it. I believe we submitted a pretrial memo. I'm not saying that would have been in it, but without the defendant, it would have just been, I think, probably nipping around a little bit.
Right, without the defendant, it's simply that he was involved in drugs, and therefore...
Hayes was involved in drugs? Or the
Yeah,
defendant?
that Madonna was
Madonna
involved
was
in
involved
drugs,
in
and
drugs.
therefore it could have been...
Could have been.
A drug deal gone bad.
That was another issue that was mentioned. I don't think counsel got a chance to address it, but that came out. Clearly, the defendant's drug use, the victim's drug use. Even Hayes was, and this came into evidence. Hayes was interviewed right away and volunteered that he had a connection 2 years prior to the same drug suppliers that the victim was involved in. He indicated that he didn't like the victim, but times had passed. There was an allegation that there was some inappropriate behavior with the sister. And I think that all came out in terms of I think through the detective, without the defendant, Detective Chevron, the lead investigator, testified.
So that came out in the sense that he says that he was told these things. The detective was told these things. Were the other people allowed to testify? Did it come out through other people that, in fact, Madonna had a drug problem?
Well, I mean, I think it was agreed that the victim had a drug problem, was, I think, a painkiller, taking painkillers that, OxyContin, that matriculated into, a drug addiction. Did other people testify other than detective? I don't know if there was, I think the answer is no. I don't think there was a need for it.
There's some discrepancy between the two briefs, but I thought from your brief that there was, I could be wrong, that Pam Madonna and one of the sons testified that something about that they thought they knew that their respective husband and father was involved with drugs. Is that?
I think it is. I think it was their impression that he may have been involved with drugs, I think. But yes, I think that came in. The son testified, his wife testified, but that was not disputed by us, that he was involved in drugs. I think the defendant tried to take it to another level and say he was involved in drug dealing, which we say there was no evidence submitted in the record of that, or credible evidence.
Mr. Quinn, I thought I heard you say at the very beginning of your oral argument that the defense wanted to present its theory of defense in a certain way, and my ears perked up, and it sounded to me as if you were saying there was a way in which some of this evidence that didn't get in could have gotten in, but counsel had his blinders on, and he wanted to get in a certain way, and he couldn't. Are you suggesting that the defense was botched somehow?
No, not at all. What I meant by that was the certain way references an attempt to elicit and introduce evidence that was not admissible under the standards that the court was applying. No, counsel, I mean, self-serving, did a very good job. Frankly, I thought pushed the judge too much on a lot of stuff at sidebar, and as I said, saying, I don't want to try this again, and again, but he did a very effective job bringing out that theory. There was ample evidence of it, that Hayes was the killer. And if there are a few instances in which certain evidence was excluded, I would argue that it was an appropriate use of discretion.
Why did you, the Commonwealth, object to the way that the judge initially wanted to answer the jury's question about whether the defendant could have called Hayes? It seemed to me a more neutral explanation than what she came up with post-objection.
My concern was that it would not be portrayed in the instruction, or the instruction given that Commonwealth had the burden to call Hayes. Clearly, in the interplay at sidebar about discussing it, yes, initial suggestion was made by defense, and
I thought the judge actually came up with the initial suggestion.
well, no, you're right. And then he preferred that, and then there was some dialogue back and forth about maybe adding to some of that. And I reviewed it yesterday, I think, or the day before, of what went forth. But my concern was in no way to shift the burden, because I said that, and again, I was there, I'm not saying you should consider my thought process, but that obviously is a sensitive issue. Don't want to tramp on the defendant's right not to have to produce evidence, but also that was an issue in the case, and I did not want it presented in a way that could affect us. And I think what was read, Justice Gantz indicated his practice, but if available, a witness can be called by either party. However, a defendant is not required to produce evidence, as the burden of proof is on the Commonwealth. I think that is a fair statement of the law. She had already obviously instructed in a nice paragraph the importance and significance of the Commonwealth's burden of proof, and
But they'd already heard the general instructions. So, I mean, wouldn't it have been better if she had said something along the lines that the defendant is not to be penalized for not calling? Not required to is not really quite it, is it?
well, I guess it depends on maybe your preference of the language, of the words to be used. I think it was
Well, it's one thing to instruct a jury that hasn't asked any questions. It's another thing to hear a question that sort of sets a tone. It signals a tone of where the jury's going sometimes.
Well, I think, Justice
And it may need to be corrected and put back on track.
Counsel referred to that they're obviously asking this question to penalize him. I disagree with that. Interpreting questions, it really can't generally be done with accuracy. But 4 questions were asked, too. It wasn't this isolated question. There were 3 other questions asked. They may not have had the same significance, but it was 4 questions were submitted. And I think, again, the judge, if you look at the dialogue at sidebar, I felt was very conscious of not shifting the burden of proof. She said that and was reflecting on the appropriate words to use. And I think she did acknowledge she didn't want it to be too, I don't want to say the word pro-defendant, but on the other hand, you have to balance it. You don't want the defendant, obviously in a question like that, to come out on the short end of the stick, so to speak. But if you read that again, I think that's an appropriate response to the question. And whether you could have added a stronger language or not, I don't think detracts from the propriety of this instruction.
And was there an objection to the answer, the judge's answer?
Yeah, yes, defense said, I prefer the first one, I believe. I'm speaking generally. I think the defense counsel said, I prefer the first one. But she gave, from what I could see in the interaction I had, we had other counsel.
Well, did the judge, was there an objection to the second one? Or did he say?
Formal objection, I'd have to see. He said he, defense counsel, preferred what was initially proposed by the court, or potentially himself. Did he say, I object for the record? He may have, but I'd have to review it specifically.
Thank you.
Thank you.